couldn't be avoided. We're here this evening. Discussion with regard to the two grievances that have been brought forward. So I'll call that to order. I have a copy of the proof of posting. Okay. If everyone would rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Let me basically go over how we're going to go through this evening. This is, as I said earlier, is the deliberative portion of the grievance hearing, which means that we will not be taking any more input from either side. It'll basically be a discussion between the commissioner and myself, and at some point we will not only go through the facts and come to a decision, and at a later date there will be a written decision that will be put out, and that's basically how we're going to go about that. So I think the best way to approach this is to go forward with the discussion with regard to grievance 0906. That would be the first one, and then go on to the second one. And 0906, I believe, is the fake drug one. And I believe that that incident was on May 8th, 2009. Is that correct, Commissioner Crolian? Is that what you have? Or what you've been able to glean from the information?
Well, the discipline was, data discipline was
oh, yeah, I was just going by the incident. I'm sorry, when the incident occurred. That.
No.
Okay.
No, I think it occurred, when did you say?
They have down on here.
May 8th?
That's actually when the fake drugs, I believe, but they have July 3rd, 2009 as the date here.
Well, they have the date and time of event is July 3rd, 2009 at 1 o'clock, but yet
it says that it's
that the beginning of the personnel records entry form states or reads on July 3rd, the sergeant received a package. Excuse me, the lieutenant received a package from the sergeant.
That's correct, from Detective Sergeant Chris Dupree.
Right.
Okay. And he talks about the case that he reviewed, case number 373004. But if you go on into the documents, you'll read when the incident actually occurred, the fake drugs. If you go into, I believe it's what Officer Defina brought forward.
May 8th?
Yes.
His initial report is May 8th.
Right. Okay.
And then they wanted a follow-up done on June 18th.
Right, and that
That's
has a little...
how many, 6 weeks later?
Right, that concerns me a little bit, the fact that they waited so long to ask for a follow-up. And I think that
But if I understand it right, the officer felt, it was his opinion, that no crime had taken place.
that's correct.
Okay. And that's different from what the supervisors felt. But yet, we have the 2-day suspension brought down to a verbal reprimand. It's supposed to be corrective non-disciplinary action, but yet I think there was one of the supervisors, I think in the first day, said wasn't even sure why we were here, because this is non-grievable, because it's a non-disciplinary action.
But isn't
Yeah.
anything like that, isn't it grievable?
Well, I look at it and say, well, if it's not a disciplinary action, then why do I have about 40 pages of information here that are, by the way, is all redacted? For what reason, I don't know. But yet it's maintained it's just a verbal reprimand, but yet this verbal reprimand is going to go in a personnel file. So it's either you get a verbal reprimand that's not recorded, or you get a written reprimand that is recorded. If something's going to go in somebody's personnel file, then it's discipline.
So it is grievable.
Oh, no
But
doubt
he's
about
also stating that it's, I think the comment that was made, and I think it was made by Lieutenant Klein, that it's not found in the CBA, and therefore it shouldn't be considered grievable. But I do think that something like this is grievable. And in fact, if you go down and read through the SOPs and you read that section, I don't know where I have that section with regard to, where was it? Where's the section about part of the SOPs? The section in the SOPs that speaks to both written and verbal reprimands.
And the P250s?
Yes, it's
Yeah.
the P250s, that's
Yeah.
what it is, okay? That speaks to that.
Well,
And in there, I believe it states that after they've decided to put that in there, that they not only need to speak to the you have it there,
Yes.
that you not only need to speak to the officer, but or whoever the grievant is, he has the opportunity to basically write his comments. Do you see that?
yeah,
In there?
yeah.
And I don't see anywhere in this material that was done. Do you see that statement here? See, the employee shall be further advised that he or she has the right to file a statement in her personal file setting forth, yep,
Yeah,
his or her
So-
contrary position
yeah,
in the case of a disagreement.
right. So
So I don't think
you
that
can't
was-
have it, I guess you can't have it both ways. You can't have give somebody a verbal reprimand, document it, put it in a personnel action form, and then say you can't grieve it. So I think that's done. As far as I'm concerned.
Well, the other thing with regard to this that has me a little bit concerned is the memos that follow up with this.
You're talking on this one here? We
That-
talked about
Right,
these paragraphs, right?
Right.
We questioned why did it go from a 2-day suspension to a verbal reprimand. We were told because it was just coming in, it was on the 13th, and it was within that 10-day, they were able to put that in the 10-day. And I recall talking to the lieutenant about that and asking him, and his response, not verbatim, but was that he had discussed it, and after he heard the explanation that he was getting from Officer DeFina, that he lowered that down. And
but he has nothing in there
right, I
to,
specifically asked and said, is it documented? You've got some scathing stuff here, such as in paragraph 4, claiming incompetence. and this in particular, this is yet another example of your repeated incompetent conduct. That's some pretty strong language, but yet, when we turn around and ask for explanation, none is documented.
Right. The other thing is, I wonder if they made the window that they needed to as far as the dates with regard to this.
Good.
That was another thing that had me concerned, is whether or not they met those dates.
Right.
You're talking about the memo that that was the first memo that came out, I believe, what was it?
From Detective Sergeant Chris Dupuy?
Yes,
Okay.
yeah, that came out on the 18th.
Yeah.
Okay.
This one here?
Yeah.
How come yours is not redacted and mine is?
I told you last time I was special.
Well, I'd like to know why I'm getting redacted information and you're not. If I'm supposed to be,
I think it was given and probably you
I didn't redact
purged,
it.
no, you probably purged the wrong one.
I was given two, a redacted one?
Yeah, and an
non-redacted?
unredacted one.
You know what, I'll give it the benefit of the doubt. That's all I can say.
Okay, but getting back to that, that date was the 18th, okay? And that does not meet, that was Sergeant Dupree's memo. Then you have,
But this was 6 weeks after
right,
the officer
right,
wrote up his first, right?
right,
He's got his original report dated May 8th, 2009, and then on or around June 18th, 2009, he returned those reports. 6 weeks later, how many weeks is that? 5, 6 weeks?
5 weeks.
And one has to ask themselves, what took so long? Why did this wait? Why did this come up at such a later time? But in any event,
So that was another concern that I had, that it didn't meet that window. Okay. And the other thing I saw, or I looked at, that was provided for us was Chapter 2 of the Standard Operating Procedures. And at the back of it, or in it, they have included the memorandum of agreement that was with the Hooksett School District. And there's this thing called the Hooksett School System Response Plan for Criminal Incidents. Well, first of all,
Okay, wait,
what concerned me
I wanna-
is this.
For the record, I was given the non-redacted,
Okay, just so,
Okay.
okay, I'm glad you were.
so I take that up, so I stand corrected, and I don't have
Okay.
a problem saying that.
Okay. Like I said, the other thing that had me a little bit concerned was this, the standard operating procedures, and in that document also had the Hooksett School System Response Plan for criminal incidents. And I'm surprised this was included, because this document is dated August 31st, 2009, well after that. So I don't know, you know, how the employee is supposed to,
Is that a changed version, perhaps? Or amended or updated version?
well,
Or was that the version at the time the officer was supposedly disciplined?
no, this came afterwards, and I don't know, and it doesn't show the date of signature of this agreement. There's a signature space for both the police chief and the superintendent of schools. There's no date, but at the bottom, the form does say August 31st, 2009.
So without those signatures and without the dates on there, should we even consider this?
Well,
Or is this just a copy?
I think that's just a copy, but
Oh.
where I was going with that is that on page 4 of that memorandum,
Yep. Page 4? That's not the memorandum, is it?
before, I think it's probably before that.
I have, page 3 is where the signatures are supposed to be.
Yeah, but after that document, they have this side blank, and then they have Hooksett School System Response Plan, and then they have what they call all the different areas: possession,
Right.
use, sale of tobacco
Crimes.
products,
Yep.
possession, use, sale, including paraphernalia,
Yeah.
okay?
Well, I'm still looking at the fact that this is considered a verbal reprimand, and it's under the corrective, non-disciplinary box that they have. And I have a problem with that because it's one or the other. I don't think you can have both. It's either a non-disciplinary or it's disciplinary, and I think once you reduce it to writing and include all this information as to why you're giving this, then it becomes disciplinary, doesn't it? Because once this is a personnel records entry form is completed and signed off and whatever's given, if that employee, that becomes part of the personnel file of the employee.
That's true, that's
So
true.
if somebody, if the employee were to authorize someone else to look at their personnel file, an outside agency or for other employment or whatever the case might be, then they would sign off on it, and then that outside party would be privy to this information, and it would reflect negatively on the employee, wouldn't it?
Exactly.
Especially with the strong language that's in here, with no, oh, by the way, I did talk to him, and the things that he said were plausible, his understanding was a misunderstanding, we came to the conclusion. This is one-sided, and it's not fair to the employee that it's not documented that, you know what, it's not as bad as what we first wrote.
And that's why I say that memo certainly would have been very, very important for us to see that memo that, you know, caused him to change his mind with regard to the other thing. I think there was a statement made, and I believe it was made by the chief, about the fact that the chief feels that everything should be documented, and that has not always been the case, and in this situation, it was not documented. And that's unfortunate that we don't have that memorandum.
I don't think it was ever reduced to writing, was it? There was no memorandum.
No, they said that there was a memo that they had, but they didn't include it in this packet. I don't know if it was the memorandum of why, but there's a memorandum that's missing in these documents here that have been...
It's my understanding, when I asked and made the inquiry about this, that there was nothing reduced in writing. There was no explanation
No.
put into writing as to
Okay.
why that occurred, why the punishment, if you will, which went from a 2-day suspension and a corrective disciplinary action down to a non-disciplinary action according to the
Right.
personnel records form. So that was my understanding. That was what I heard, that you know, they don't do that. Perhaps from now on they will, I think is something that was said, but there's no memorandum there.
Okay. The other thing I think that the chief also said is, when we were talking about the fact of whether or not they document or they don't document, that he made some mention of the fact that It's up to the supervisor whether or not they decide to write a form like that. There doesn't seem to be anything that shows any consistency about that, and that's a little bit troubling. I don't know if you recall the discussion about that.
I do. I still got to look at this here and concentrate. I understand that there's some things that are lacking procedurally.
There's, quite a bit.
I understand that. But when I look at this particular one, the officer made the determination, and how it came about, how it was reviewed, 4 weeks later and 5 weeks later. I don't know that we got a satisfactory answer as to why it took so long to get reviewed and then kicked back to the officer to do the follow-up. Do you recall any of that? I don't recall a reason why.
No, I don't think we were really given any reason.
Right.
There is within the information that was presented to us, Lieutenant Klein's memo in here that is on the 29th, and I think basically what he is saying is, from his standpoint or from his vantage point.
This is
not
from Sergeant Dupuy.
From Sergeant Dupuy.
To Klein.
Klein,
yes.
to Klein.
Yeah.
Why that happened. And like I say, it's a little bit troubling to be, dealing with something that far back. The other thing I think that the officer makes mention in his notes, what he calls the gist of the grievance. Did you read that? The gist of the grievance?
Yeah.
That originally they didn't have any problem with it, and then all of a sudden Captain Cecilio gave a bunch of reports back to him and told him to follow up on.
Yeah. I still got to go back to this here, and I understand all those particulars, but I still go back to the actual grievance and the action that was taken, and we would have to make a decision on the grievance itself without going through the entire testimony now, over again. When I look at the reports that were submitted, the bottom line is that the officer felt that there was no crime committed. When we talked to, and some of the evidence here, and in his report, the portions that I can read in his report, he says that it doesn't justify, he didn't justify that a crime had taken place. The fact that his supervisors felt that there was, then if a supervisor in a detective or investigative division thinks that something needs to be followed up, perhaps the investigative division should follow it up.
What you're saying, that it should have come back from Detective Sergeant Dupuy?
Well, no, what I'm saying is the officer is being written up in a non-disciplinary way. Actually, he was written up disciplinary-wise,
right.
but then it was
Changed to non-disciplinary.
Non-disciplinary.
Right.
He maintains that there was no crime committed in his initial investigation. If something changed, or perhaps the investigative division should have looked into this, and they could have certainly overridden his decision. But it's kind of twofold here. But I look at it as it is a disciplinary action taken. even though they check off verbal reprimand, non-disciplinary, then if it's non-disciplinary, why the heck is this in a file? If it's not going to be used against the employee, why is it even in a file?
But I think if you look at those SOPs, I think it does say in there that it becomes part of, you know, the file, and, you know, that's another story for another day with regard to that, whether or not that's, you know, the right approach.
Yep.
I think it gets down to probably, you know, the fact of the officer saying that he didn't feel that those fake drugs.
Well, I think in his report, he indicated that there was nothing about sale. So, right. The question I look at is why was he disciplined to begin with? And then why was it changed? Why was it sent down to a verbal reprimand from a 2-day suspension? If it's because he gave something that was plausible, gave his opinion to the lieutenant, and said, and the lieutenant obviously must said that he understood his side of it,
Right.
and he understood that, well, then I guess this has to go away. But,
Although this here is 2007, part of this, read this, which is part of the Hooksett School System Response Plan for Criminal Incidents, okay? And these are the guidelines. These are the guidelines used by the school, but
Right.
read that.
this one up here, response on tobacco products?
Tobacco
Okay.
products and,
All right, let me read it. Anyone found using tobacco products on any gym facility shall be reported to principal. Principal shall notify school liaison officer promptly. The school liaison officer shall have the discretion to issue a warning on the first offense and issue a court summons for any subsequent offenses. But that's for
right,
tobacco.
okay, but then you go on here,
With drugs, okay. Any student observed possessing, using, or selling of any of the above described substances is to be immediately brought to the principal, right? Any substance observed will be immediately seized and put into a clean envelope and immediately turned over to the police. The principal will promptly call the police in every instance where drugs or paraphernalia are discovered. Note, no school employee has the lawful authority to destroy any item seized, suspected illegal substance. Even the police will eventually need to obtain a court order in order to destroy the drugs. Is this what you're talking about?
Yeah.
Okay. The principal will have a question of the student and direct that medical attention be brought appropriate. Parents will be called,
which they did.
right, if there is any suspicion of drug or alcohol use. The Hooksett Police Communication Center will be called and the SRO assigned to investigate.
That's all it says.
Okay. Well, he investigated it
Yeah.
and found that there was not an illegal substance, correct? I think at his point, I don't see, is there anything in here, was this ever investigated by anybody other than Officer DeFina? Was the investigative division, juvenile division, anybody investigate this besides Officer
I think
DeFina?
they took it back and did some work on it.
Who did? And what was the ultimate outcome of any investigation? But regardless of that, regardless of all of that, this on its face is disturbing when there's nothing that changes this. There's nothing that says, oh, by the way, we spoke to him. This is left on a face value.
Right,
And there's a problem when it's this scathing,
right,
and then we change it.
right.
Why?
Right. And the other thing is, like I said, there is nothing that he was able to refute or in his file.
Mhm. So, I don't know.
Plus, I don't think they met the window. I think they waited way too long.
In
For
the
an incident that happened then, in May, and then to have this, the chief finally signed off on the 15th of July is way too long. And in fact, I think in their rules, it says that they only have so much time to deal with it.
For discipline?
Right,
But it's non-discipline.
right.
Or is it discipline? No, wait a minute, it's non-discipline. No, it's discipline. Am I confused?
You know, you can say that it's non-discipline, but it still is discipline to the degree that it is still included in his personnel file.
Absolutely, that's what I've been saying all along. It is discipline. How can you write stuff like this, that he has and the department has, and then put it in a personnel file and say it's not discipline? You know what? Had this been gone, or redacted, or rewritten, had there been something else that followed this up that said, you know, it wasn't as bad as we thought? We understand his side, and this is what he told us?
Yeah.
Then that would be an understanding of, oh, wait a minute, there's page 2. Page 2 says, on the heels of page 1, that maybe it's not as bad.
Right. I don't think this verbal reprimand goes with, first of all, it doesn't go with what is at the bottom here, because what is at the bottom is for the 2-day suspension, and in 11B and C, B, which says an unwillingness or an inability to perform assigned task, that goes with the 2-day suspension, as well as the failure to conform to work standards established for the employee's rank, grade, or position. That goes with that. There is nothing here that really speaks to
The
that.
the allegation, according to this, is that he's incompetent.
Right.
So he's incompetent, according to these charges, but yeah, we're going to give him a verbal reprimand. Don't be incompetent anymore. I don't understand. There needs to be explanation. We don't have it. As far as I'm concerned, this is dead in the water.
Well, I think it's, you know, certainly unfortunate that if, you know, this, and in this case, it's a corrective non-disciplinary action, a verbal reprimand, that it does not have with it part of the discussion or some notation about the discussion about why it was changed and to reflect that.
There's
Because
nothing that substantiates it.
no, there's nothing in there to substantiate it. And like I said, going back to the fact that there are several things that point to the fact that this should not be allowed to stand, because they didn't even meet the criteria established, you know, for this reprimand. They passed the window. So given those particular points, that's where I would go with regard to that. That's my feeling with regard to
So
06, 07. So I guess,
We-
I don't know if you concur.
that this, in the interest of maintaining RSA 91A, I'm not going to comment anymore, other than I think we should probably make a decision here.
Yes, that's what I was asking.
Yeah, because there's certain things that can't be said, so.
Okay. I think you would probably need to make that into a motion. Based on the facts that we brought out or stated earlier.
I'm going to make a motion that this personnel records entry form be stricken from the employee's personnel file. And I'm going to make a motion that we find in favor of the employee based on the evidence that was presented, as well as the lack of evidence presented, I guess, and that we find in favor of the grievance.
Do you have that, Dawn?
No.
Could you repeat it? That's why I asked you.
You already, I'm sorry.
That's
I learned
That's
from
okay.
him, I've learned
Sometimes-
from him never to write down first because he
Sometimes
always
I do better on the
sometimes
second or
he
third
changes
time.
it.
Okay,
I'm sorry.
that's quite all right. I'm making a motion
Mhm.
that we find in favor of the grievance. That we find in favor of the grievance
Yeah.
on this grievance, which I think
Oh,
numbered it
0906.
0906, and that the personnel records entry form for that grievance, and that personnel records entry form is dated 07/13/09, be removed from the employee's personnel file for the reasons that were stated.
Did you want to write in there? I know you said the first one that you, for,
I'm sorry?
yeah, I know you said the first one. I know I got bits and parts of the first one where you said that for lack of evidence. Did you want that one in this one too? In this part when you got it back?
You can just make it the decision, that'll be fine.
Okay.
I think we're gonna have to go down, when we write it up, we're gonna have to put those, all those points into the decision, when we write it up.
I think once we render a written
Right, yeah,
decision.
right, that's what I'm saying.
The written decision will
Have
have
to include all those,
the issues
okay.
that we discussed.
but this is simply the motion. Motion to find in favor of the grievance for the 0906, and that the personnel form, personnel entry form
Be
for the
removed.
grievance for 7/13/09, removed from the employee's personnel file for the reasons stated. Okay? Any discussion? I'll second the motion. Any discussion with regard to that? Any other comments or discussion you want to?
I'll vote in favor of that.
Okay. All those in favor of the motion signify by saying aye.
Aye.
Aye. Opposed? Okay. That's for 0906.
That's the one dated July 15th, 2009? That would have been 2 days prior to this one. We just did.
With the incident date of 12/11/2008. when you say that the July 15, 2009, I think you need to be specific and note that is the date that the employee was notified of the action with regard to the personal entry forms and that the chief signed off on it. Is that correct?
Yes, the incident occurred on December 11th,
That's correct.
but yet the discipline was handed down July 15th.
That's correct.
That's
I
the
just
one
wanted
he
to make
got a
that clear.
Written reprimand and remedial training.
Right.
And the charges were prohibited conduct, conduct unbecoming,
Right.
incompetence,
Right. On the second page.
required conduct, submitting reports, and truthfulness.
That's correct.
I think that based on the evidence that was presented, I think it's a clear case of double jeopardy.
I agree, and that's what I found really not only disconcerting about the fact that that was the same one that he had already been given discipline for on 12/23/08. That was a little bit disconcerting about the fact that it was already, he already had received discipline and then to go back and do this. But I guess what we were told with regard to this one here it was based on the what he had included in the report on both December 16th and December 19th, and that was the reason for it.
Yeah, in the conclusion, there's something that I found interesting in the conclusion. It says that rather his explanation smacks of gross incompetence or insubordination on his part. I look at that as apples and oranges. If somebody is incompetent as opposed to being insubordinate. When you're insubordinate, I take it that you're not following directives, you're not following orders, and that you're being insubordinate to your subordinate supervisor, right? And if you're grossly incompetent, that's a whole other issue. But the facts that were presented, and we were very specific, and we asked, matter of fact, all the same things that were charged in this were charged previously, and he received discipline for on the 23rd.
Right?
We inquired about an internal, and the internal came up with a different, an internal was conducted based on a different accusation. However, this
Could you please explain? Yeah.
Well, the employee didn't get copies of the internal,
Right.
and the internal was used against the employee for disciplinary purposes. And the internal is to be afforded to the employee if it's used in disciplinary action. That wasn't done. Although the internal was conducted, and no doubt in my mind it was conducted properly, the end result and what was done with that IA is it's not contained in this one, in this personnel records entry form, as far as I can tell. And if if these things were so egregious, and these accusations of, I mean, this isn't one thing. This isn't, hey, you lied on these dates, and therefore we're going to discipline you on it. This says, okay, prohibited conduct, conduct unbecoming, incompetence, violation of chapter rules 1 and 2, chapter 1 rules and regulations, required conduct, submitting reports, truthfulness. I'm just wondering if anything else could have been added to that single thing, because the other stuff was addressed.
That's true.
All that stuff was addressed, and the discipline was given out, and I believe it was grieved, and then the discipline was lowered in April of 2009. So I guess what I'm saying is it's a double jeopardy issue when it comes to this, because he's already been charged and grieved it and took whatever decision was made by the commission in April.
I guess where I was coming from, the part of it that had me a little bit concerned, certainly not a little bit concerned, quite concerned, is the fact of the same day that the incident originally happened, which was on December 11th, there was another incident, and in listening to the discussion or to the questions that were posed by different members of the department, the other issue that occurred that day, they did not take with the same amount of seriousness, and that case, I believe the victim was not spoken to until 7 days after, and then the final report wasn't done until 13 days. And I guess if you're looking at a standard, the department should first of all, first and foremost, set the standard. You know, first, I mean, you know, at a minimum, that's the way it should be done. For them to do less than what they needed to do is very disconcerting in this regard, and I wondered why they felt the need to go forward and you know, and have a written reprimand when they already had dealt with the situation previously, and there was no need to do it. But I believe the statements that were made based on the fact that it had to do with some of the statements that were made or what was included in the report on December 16th and on December 19th, that they were zeroing in, and they felt that there was a lack of truthfulness and whatnot, and that's why they chose to go forward. But like I say, if you look at both situations,
but they went forward with the same set of facts.
Right.
And pretty much he's been tried twice. Right. On the same set of facts, notwithstanding the other information that came to light when he was given that reprimand, which started an internal. Mm-hmm. Okay. But you have to, I mean, I look at, again, it's, you can't have it both ways. When somebody comes in, if he's being ordered off his shift, you know, we're telling you to go home. No overtime for you. And the employee goes, okay, I'm out of here. Time's up, I can't be here. But then it comes back and goes, well, wait a minute, you didn't tell us, you were supposed to tell me about some stuff. Well, what is it going to be? You either stay here and tell me about it, tell the department and make us aware of it, or No overtime, go home.
Exactly.
I mean,
I think
if
the
if-
department
if-
had a responsibility.
Absolutely. If I'm the responding officer and I'm dealing with something that is that heavy, and I'm talking about the, excuse me, the child pornography, because to me that's, I think others would agree that's what it is. That officer is getting no assistance. He's overwhelmed, he's getting no assistance, but yet it's his responsibility to make sure he does the investigation on it. And then he makes the attempts to try to pass this along, and then finds out about the fight. And the fight doesn't become, at that point, that fight, from what I've heard, was not a hate crime at that point. It may have developed into a hate crime
With the threatening.
down the road, but the responsibility of the officer and with the harsh attitude, and I say it's a harsh attitude, of, you gotta get out of here, no overtime, you're not to be here. And aside from what one says something occurred and the denial of the other saying it did not occur, aside from that situation, looking at what was going on, they still want to know, what's your answer? You better tell me you're on your own time and get out of here. If I was the employee, I would have said, see you later. Why is the employee going to be held to that?
Standard, right.
All of a sudden, it's like, well, you didn't report it to us. We got reports here that went weeks, no follow-up. Does anybody get in trouble for not investigating it? They say it's an ice storm. What, crime stops because there's an ice storm? Investigation stops? I don't think so. I think it's just a lame excuse.
Well, the other
I've said
thing is that at some point, probably, you know, at a future meeting, we'll have to deal with issues of the fact of, you know, when is overtime permissible, because just to have a blanket statement saying no overtime in situations.
For the SRO.
Right, that's right, for the SRO in this situation.
I'm not sure if there was overtime afforded
Right.
anybody else.
Right. That's unfortunate because it appears that there certainly was a need for, not only for the officer to be there and to probably get some backup, but for him to be allowed to complete, you know, what needed to be done and to be able to handle that, and perhaps even get somebody to come down there. I really find it very troubling to hear not only that someone says that, but not to give a call back, you know, and say, what is the issue down there, explain it to me, and then make a determination, but just to make basically a blank statement, say absolutely no overtime is concerning. I would think that you would want to know what the facts are, what the situation is, before you decide. So this is, that's pretty disconcerting with regard to that. And the fact that there is a written reprimand, and it definitely is double jeopardy.
If you know what is just inexplicable to me at this point, and it doesn't make sense to me, is these charges. These are serious charges. This is serious stuff.
You mean from the conclusion?
Absolutely. You know, for a police officer to be accused of untruthfulness,
It's very serious.
as far as I'm concerned, it's career ending. It can be
Exactly.
career ending because we expect higher from law enforcement officials. We expect them to tell the truth. And that goes down the line. But when you have charges that make those allegations, and yet You want to give them remedial training? You want to give them a written reprimand? I find that troubling. You know, what is the purpose of that? What's the reasoning behind that? We don't have that, just like we didn't have it for the reverse, you know, for the lowering of it, so.
But you know, this one here is also corrective disciplinary. Unlike the other one, which was non-disciplinary, this one here is disciplinary, whereas the one that he received earlier, and he got the suspension, there was disciplinary action taken that he, you know.
On December 23rd.
Right.
Yes, that, for the same set of facts and the same circumstances and the same allegations, I think we've made clear, and I think what is outside of that is the internal affairs investigation.
But what I'm saying
But
is.
this doesn't address that.
Right, but what I'm saying is, on December 23rd, there was disciplinary action. He was suspended 5 days, okay?
And
Then you come to this.
What was the action? What did he do? What were the dates involved there? And what was it for? So, is it for the same stuff, the same action, the same things?
Well, he says, neglected to report this assault in a timely manner.
Which assault?
The assault that happened on the 11th of December 2008, okay? And he said this is a violation.
But didn't they already?
No, I'm just saying that, I'm trying to make the point
Right.
that they were two
Right.
disciplinary things for the same thing.
And they took care of that on this
Right.
23rd, December 23rd issue about the fight in the school,
Right,
right?
Right.
And not reporting it and doing that. But then we come up, and now we have another one.
right,
what
and
is
that's
it-
what I'm
what is
saying,
it-
and they're both,
What does it talk about? It talks about the same stuff.
right. But they're both disciplinary. This one here didn't turn around to be a verbal reprimand, it didn't turn around to be counseling or anything like that. It is in the category of corrective disciplinary, like the other one. And that's not only what makes it double jeopardy, but it's like getting the same punishment for, basically the same thing, except they made it a little less. He didn't lose time and he didn't lose pay. That's the difference. That's the difference with this one here. But it's still, so there are a number of issues that come into play with regard to the other thing is that I read in the documents that that on December 16th, the SRO officer said that the Colley School principal had already taken care of the incident. And so therefore, as the officer stated, he didn't think it needed to be addressed. He was following up with those reports, only doing as he was asked to do, basically, and not what he, as a normal officer, would do when he's following up with something. That he was doing basically what they were telling him or directing him to do. The other thing I think that Officer Defina brought up is the fact that with regard to the posting, the threatening messages that they did, Lieutenant Klein did direct 2 detectives to go down to the school, and it's only at that point that you know, he sent somebody over there, but it didn't seem like he took any of this serious enough. So I don't know where we stand with regard to this, except for the fact that it appears to be double jeopardy. It also appears that when you look at the incident of the texting, the sexting, not the texting, the sexting,
Child pornography.
yes, that issue, that the department basically kind of fell down and only interviewed the victim 7 days later and did the final investigation 13 days later, but yet they're expecting something different of the employee, and But like I say, I keep on going back to the fact that I don't understand why this one here is a written reprimand, why it didn't go to the verbal or the counseling or something like that, but in the end, they all end up in the personnel file. Because if you have a personnel records entry form, they eventually all end up in the file. Is that not right?
That's what seems to have happened. Yep. Yeah, you know, this one here, we look at this one, and you try to judge that the punishment fit the alleged crime. This one here, 2 days is recommended for incompetence. This one here, written reprimand and remedial training for all those other things, including untruthfulness.
Right.
Doesn't make sense, does it?
No, no.
But that's what they chose to do, and I guess that's why we're here. So, I mean, I don't have any further discussion on this. I really don't. I'd be more than
Are you
happy.
ready to come to a decision?
I am.
Okay? What our conclusion is? You want to make a motion?
I do.
Okay.
Good to go? I'll make it simple.
Okay.
This, by the way, is 0907?
This is 0907, grievance 0907, which is dated for the offense December 19th, 2008. And the reason I say that is we had some issues with the
Yes.
numbering of the grievances.
Right, right.
Okay,
What
so
was the date again?
the date is
December 19th,
December 19th, 2008, which consisted of a written reprimand and remedial training. Motion is that we find in favor of the grievant. And that the personnel records entry form be removed from his personnel record.
File.
Hmm?
File.
I'm sorry, his personnel records file, personnel file.
Do you want to state the reasons?
For the evidence that was presented, based on the evidence that was presented, we feel it is double jeopardy.
Do you have anything else to add besides the double jeopardy? You had made some statement about, does the punishment fit the crime?
I think the double jeopardy speaks for itself. I really do. I mean, none of this is not part of the motion.
Yeah, that's it.
None of this fits.
No. Well, as I said earlier, the only thing that I had concern about was the fact that they were both corrective disciplinary, whereas in the other instance, 40906, they turned around and made it a verbal reprimand and not in the same,
Not a disciplinary?
right. Not this.
And they believe that it probably couldn't have been grieved?
And that's why they said that it couldn't have been grieved, and in this situation, I don't know what the lieutenant felt about this one here, that, this was a different circumstance and this one could be grieved, but in this case, certainly can be grieved in this one.
I think they both could have been grieved. I think we...
Right, but I mean, I think, from the comments that he's made, this is certainly very, very grievable, and as is the other one, but this one here is so evident that it is grievable.
Yeah, and I think the chief had made mention that the whole grievance, we're in the wrong step, that it doesn't get heard by the commission. And
Yeah, there was a little misunderstanding with regard to step 3, as far as that's concerned, because I think what he was basically saying is step 3 is just the notification, and it was more than that.
Right, and I think it's evident by, 1, the language of the contract, 2, they've had prior hearings
Right,
with the commission in April.
and those were probably all on step 3. Right.
So anyway, but my motion, can you read it back, please?
Commissioner Curley, I made a motion for grievance 0907, which is dated for offense 12/19/2008, which consisted of written reprimand and remedial training, found in favor of the grievant, and that the personal records entry form be removed from his personal records file. Based on the evidence presented, we feel it was double jeopardy.
That's my motion. Did you get that?
Yeah, she got that perfect.
You did a good
Second.
job.
Any other discussion? Anything else that you want to add to it? No?
And I'll reserve that for...
For the, putting together the written, all our reasons? Okay. Okay, because we're certainly going to have to alliterate all the different things that we found.
Yeah,
Okay?
there'll be a written decision.
Right.
And
I'll
I think...
second.
Okay.
I'll call for a vote on that motion. All those in favor of the motion signify by saying aye.
Aye.
Opposed, and none. Okay. I guess the only thing left at this point is that, as I said at the beginning, the commission will need to put this in a form of writing based not only on the decisions we've made, but how we substantiate the decision. Okay, given that fact? I think we're all done, and I think we need a motion to adjourn.
I'll make the motion that we adjourn.
May I interject for a second?
Oh, sorry.
You've taken votes and you want these removed from the personnel file, correct?
Yes.
I guess the only question I have for you, and I just throw it out for this reason, at the time this transpired, there's a litigation hold on all materials involving Officer Defina based upon litigation that's at hand. So my question is, what is the desire of the commission as far as removing these from the file? Should they go somewhere else until after the litigation hold has been dealt with?
I think that the decision that's been rendered here should be forwarded to all parties concerned. So everybody that's involved in the litigation on both sides is aware of what transpired here and what the decision is and what the decision about removing that, and they can do what they want. hold, I
think
I would
that's
say
a
that-
question that they'll have to take up with the attorney that's representing,
the department,
right,
I certainly wouldn't destroy them.
I certainly need them.
But I think maybe they can be kept in a file,
Separately.
maybe kept separately, as opposed to being in the personnel file, because I don't think it would be right to have that in the personnel file. But certainly, everybody involved should know about that.
Okay. No, I agree that they should be immediately, based upon your decision, removed from the file. Just want to throw that out there about the hold and get your thoughts.
That's a good point. That's a good point.
And go.
Right, and that makes perfect sense, and, you know, we don't, in the decision-making process, don't take into account the civil ramifications and the civil, I can't even talk about it. I would say, hang on to it.
Is that it? All those in favor of the motion signify by saying aye.
Aye.
Aye. Opposed?